We have got a full house today. Please be seated. And on behalf of my colleagues on the Iowa Supreme Court, welcome. People who are here just to watch the hearings, but the mass crowd here today is Baxter High School, from what I understand. What I'd like to do is introduce myself, and I'm going to tell you what high school I went to, and my colleagues are used to that. I started doing that when I became chief, and I want everyone to know we all graduated from high school, and we did a little more after that. But everyone has that in common for sure. And I'm going to shake it up a little bit today, and they don't even know I'm going to ask this question, but I want them to also tell what was their extracurricular activity in high school. And if they didn't do one, that's because they were super studious, and I have a pretty good idea which ones those might be. So anyway, my name is Susie Christensen. I'm from Harlan. I graduated Harlan High School, and I am, if anybody would talk to you, they would probably think of me as being the girl in band. So I was in band.
Tom Waterman, Bettendorf High School, and I was on the swim team and school paper and student council.
Ed Mansfield. I'm an Iowan by choice. I went to Lexington High School in Lexington, Massachusetts, and I was on the math team.
He's the guy I figured might be.
Christopher McDonald. I graduated from Des Moines Lincoln High School in 1992, and I was on the speech and debate team and the math team.
The other one.
Hi, I'm Dana Oxley. I graduated from Greenfield High School, which is now Nottoway Valley. I ran track, and I was on student council.
I'm Matt McDermott. I went to Kemper Catholic High School in Carroll, Iowa, and I did sports, running and basketball, football.
I'm David May. I am also an Iowan by choice. I went to high school in Kirksville, Missouri, and I was on the wrestling team.
You know a little bit about us. Thanks for being here. Now we're going to do what we really came here for today, is to hear some oral arguments. The case of State of Iowa versus Clayton Brown is hereby submitted without oral argument. Our first oral argument for the day is Randolph versus Aidan, and then third party appellant is City of Sioux City. And it's my understanding that the Randolphs and Sioux City are going to be represented by the argument of Stephen Postolka. Is that correct?
That's correct, Your Honor.
Okay, and you may proceed. Let the kids know what high school you graduated from.
My name is Stephen Postolka. I graduated from Sioux Central High School. May it please the court. Counsel. Your Honors, it is fundamental that you cannot sue the government for failing to enforce the laws well enough. Yet, that is precisely what Aidan has done here. The city has adopted a building code, and Aidan alleges that the city failed to hire a competent officer to enforce that code. Aidan does not allege a violation of its constitutional rights, nor does it allege that Inspector Goff committed a tort against them personally. Rather, Aidan merely alleges that the city should have provided them with a better or more competent housing officer. This type of claim has always been held non-viable under the public duty doctrine, but more importantly fails under 670.41J as well. For that reason, the city respectfully asks this court to reverse the decision of the district court and to hold that Aidan's claims fail as a matter of law. The posture of this case is thus. Aidan operates a rental property in the city of Sioux City. Lori Randolph is Aidan's tenant and alleges that she fell on a defective staircase at Aidan's property. Aidan, in turn, contends that Doug Goff, an inspector for the city of Sioux City, had examined the property prior to Miss Randolph's fall and failed to find that the stairs were out of compliance with the city code. Those are the allegations in the petition, and again, the city would respectfully ask you to disregard those documents that do not appear in the petition. The city, of course, brings to you two arguments today. The first is that Aidan's claims are barred by the third-party immunity provision of section 670.41J. As to that subsection, much of Aidan's argument focuses on the distinction between the phrases based upon and based upon and arising out of. Specifically, the distinction between a claim that's based upon an act of a city employee, as sub J says, and a claim that's based upon or arising out of an act or omission of a city employee, as sub K says regarding emergency response immunity. Aidan contends that the phrase based upon or arising out of is wider than the phrase based upon. And yeah, that stands to reason, but let's just look at the based upon language of sub J. What is Aidan's claim based upon? It is not based upon Inspector Goff's alleged missing of a defect in the course of an inspection. I think we all agree, including Aidan, that the city would be immune on that type of a claim. So what claims did Aidan bring? Negligent hiring, retention, and supervision, and then contribution. Ergo, Aidan's claims are based upon the city's acts of negligently hiring, retaining, and or supervising Inspector Goff. So what does that mean for this case? Well, at this point, we have to remember what sub J is for. It is not inspections immunity. Rather, it is immunity for any claim based upon any act of the city, whether by permitting, inspecting, investigation, or otherwise, so long as the damages are caused by a third party. It's that third part, yes?
Otherwise, in that list, to say that it applies to any act when the property is held by a third party?
Your Honor.
That it applies to any, that otherwise means anything, wouldn't that defeat the inspection and the words earlier in that sentence?
I would say no, and the reason for that is, and of course I'll get into the public duty doctrine a little bit later, but these types of immunities are complementary, right? So if we want to think of a unified theory of immunity, we can think of it as kind of a flow chart, okay? So the first question is, well, we have a victim, right? Was the victim injured by something that was owned or controlled by the city? That's the sub J question, right? And if the answer is yes, then the city is not immune. If it was owned by a third party, immunity. If it was not owned by a third party, then we go to the public duty doctrine questions, right? The way I read sub J is that or otherwise is a pretty immune phrase, or a pretty broad phrase, excuse me. But even if we read it in a nosi tura socis or something like that, we can see that the legislature was clearly contemplating inspections when it made this statute. And this type of a claim, while it, might arguably arise out of an inspection, right? And it doesn't exactly say rise out of in the statute. We can see that we're in the same world here, right? We're in the same world and types of claims. So,
Counsel, a fact question. The victim fell down stairs. That's the underlying injury. What was wrong with the stairs?
the stairs had uneven risers and treads, meaning they were not the same height from one another or the same depth.
And are you disavowing reliance now on the latent defect inspection provision? Or are you relying on that in the alternative?
We are not relying on the latent defect immunity at this time, at least. As it's pled in the petition, I don't think there's facts that would suggest this was a latent defect. A latent defect is something, of course, that is not open and obvious or not discoverable on a reasonable inspection. I'm assuming for the sake of argument that the stairs were. Aidan says in their position that Inspector Goff was a bad actor. You should have known that, or not a bad actor, but a bad hire, rather. You should have known that. You shouldn't have hired him. And that's, we can take that as fact on its face for the purposes of this motion, but the fact remains that Inspector Goff did not cause the damages to Ms. Randolph. Williams versus Bayers establishes as a matter of law that cities do not control buildings within the meaning of sub J merely because they have inspected them. The legislature has seen fit to grant immunity to cities in these kinds of circumstances. And if we think about the intent of the legislature in enacting sub J and including that or otherwise phrase, while also having cities set up inspection departments, on the other hand, what would the intent of the legislature have been here? Surely it would not have been to turn cities into general liability insurers. It's notable that the legislature could have done that. They could have taken that tack, and it would have been very easy because all they would have had to do would be to allow Chapter 670 to stand as is following the Wilson case. That was the approach that the Wilson case took when Iowa only had due care immunity, okay? In fact, the city, however, submits that Wilson is no longer good law because the legislature enacted the other immunities in 670.4. The reason is that our legislatures added that inspections and third-party immunity because they wanted to have cities ensure a reasonable degree of safety and inspection of the properties in their jurisdiction without making them responsible for the buildings in general.
Don't we have some cases, though, that have found that cities are not immune for negligent hiring and retention and supervision, like Sioux and Aidan? And how do you deal with that?
So, if the claim was merely a negligent, I agree that in general, yes, cities are liable for negligently hiring, retaining, and supervising their employees. The case law establishes that well enough. But that's only if the employees themselves committed a tort. That was the sexual harassment and abuse cases that Aidan cites to. The other case where a city might be liable is if the city owned or controlled the implemented issue. Example, if Inspector Goff was barred from driving, and we hired him anyway for an inspections position, requires you to drive, and we knew that, and we hired him anyway, and he runs down someone with his car, the city could certainly be liable in that context. But that's not this case. Again, Aidan said, you should have known he wasn't qualified for his job, but as a matter of law, under Williams versus Bayers, Inspector Goff did not cause the damages to Miss Randolph.
Immunity. It's not that he didn't do anything wrong, he's just immune from that. Is there a distinction there? So he still did an underlying act that would be a tort, but he is entitled to the defense of immunity.
So at this point, okay, so Inspector Goff is immune for acts of inspection, that's sub J, right? But that's also where the or otherwise language comes in, right? And if we're going to argue that the city is liable for negligently hiring, retaining, or supervising an inspector, why else would the legislature have included that or otherwise language?
Otherwise covers things related to the city's involvement in inspection? I mean, the otherwise is what you're hanging your hat on to extend it beyond the inspection to also negligently hiring and supervising.
Correct, yes. In cases where the third party controlled the implemented issue, okay?
Counsel, I want to go back to what you were talking about at the beginning as far as based upon. One could argue that their claim is based upon all the elements of the claim that they would need to prove to move forward, right? And so doesn't the apartment complex, don't they have to prove not only that you were negligent, that the city was negligent in the hiring supervision, but don't they also have to prove wrongdoing in the inspection by the inspector? And so I guess to me, isn't their claim in some way based upon both?
Based upon the inspection, then the city is clearly immune, and I think everybody agrees with that. But it's the or otherwise language that the city submits here encompasses those broader types of claims.
That, it seems to me, maybe you're arguing for the broader immunity when only, as Justice May suggests, all you need is the narrower one. I mean, it seems to me if the based upon language doesn't apply here, then you run into this problem that people can just use a negligent hiring claim or a negligent supervision claim to get around what would otherwise be an immunity, which is, I mean, that's clearly what is being done with this third-party claim. That's what they're entitled to do as good lawyers. So why can't we say that this claim was based upon an act or omission of an officer by an inspection? What's wrong with that?
Certainly nothing wrong with that, and all I would say is the or otherwise language removes all doubt that immunity is applicable here.
There's a big deal made about the broad language in Cubit, but Cubit has a footnote saying they're not deciding whether the claim would also be barred by the based upon language, right? Yeah.
As to the public duty doctrine, with my time left, I'm assuming that another responsive argument from Aidan is going to be that, well, yes, a third party caused the damages, but you, city, still negligently hired a bad inspector, and you should be made to answer for that. This, as I alluded in the beginning, is simply a claim that the city did not enforce its laws well enough. Consequently, it fails under the public duty doctrine. The classic statement that we all probably know by heart is that a duty to all is a duty to none. But what does that mean in this case? Well, when we look at Aidan's claim, we can see that it boils down to this, that the city did not enforce its housing code properly. Yes, we had dangerous stairs, uneven risers and treads. Yes, we were violating the building code, but you, city, should have stopped us. Courts have never recognized such a claim, and Your Honors, we respectfully submit that this is not a place to start. Again, going back to the flow chart I alluded to earlier, the first question we should ask for municipal liability, at least in terms of synthesizing sub J and the public duty doctrine, is, was the implement controlled by a third party or owned? If the answer is yes, immunity. If the answer is no, then we ask the first public duty doctrine question, which is, was there an act of misfeasance or nonfeasance by the city, right? And if the answer is misfeasance, then the city's liable, okay? If the answer is nonfeasance, then we ask, finally, the second question of the public duty doctrine, which is, was there a special relationship? We submit that missing something in the course of a defect, or indeed negligently hiring, retaining, or supervising is an act of nonfeasance. This was something controlled and owned at all times by the landlord, and there is no case law to suggest there was a special relationship here between the city and Aidan. If anything, there was a special relationship between the city and the tenant, but there's not even a basis to say that. The public duty cases that have come before this court.
Misfeasance, nonfeasance analysis, if the relevant legal fact is the hiring decision and not the inspection issue, why isn't there misfeasance in having no hiring criteria or not applying a hiring criteria?
Sure. So then we have to come back to, well, what is the actual basis of the claim here? And the basis of the claim is that we could have enforced the laws better, but we didn't. That is simply something that courts have never recognized. And for that reason, Your Honors, we respectfully ask that you reverse the decision of the district court and remand for dismissal of the petition. Thank you.
Thank you. Mr. Voss?
I graduated from Pella Christian High School, grew up in Newton, so not that far from you guys, but it was a long time ago. May it please the court, Mr. Postolka. The city hired a housing inspector whose prior work experience comprised of driving a potato chip truck for 14 years and then serving as a grocery store butcher for 8 years before that. None of that work-related experience is relevant to the job description, and none of it actually would be germane to the job of serving as a housing inspector. So after Mr. Guff was deposed and his qualifications became clear, Aidan filed a third-party petition for negligent hiring. Iowa precedent is clear that negligent hiring is a freestanding tort. It is not vicarious liability, but it focuses not on the action of the employee, but on the action of the employer in
Still have to prove sort of the case within a case, that there was a negligent inspection of the stairs, right?
an underlying wrongful act. That is correct. And
why isn't what you have a claim based on an act or omission of an officer or employee of the municipality in relation to an inspection if the damage was caused by, where the damage was caused by a third-party event or property not under the supervision or control of the municipality? Why aren't we within that language?
I think it's the distinction that you had alluded to in that Cubitt's first footnote notes that there's a difference between based on and arising out of. And I think Iowa precedent has recognized the breadth of arising out of, but we would submit that the claim here is based on the hiring decision.
Let me push back on that just a little bit. I don't remember there being a case cited that would be limited enough to exclude the situation from the based on language. I don't know what your best case is on that, you think?
I think that's a fair observation, but the reason why I can't cite a case on it is that every other subsection in 670.4 subsection 1 has that arising out of language other than the one immediately preceding, which is also just based on, and there's no cases on that prior subsection. And so from that standpoint, Cubitt's footnote and the distinction it's making does make this an issue of first impression for this court, because we've never had to look at the situation of just based on. The court's been construing based on or arising out of.
So we usually try to use plain language where the legislature hasn't provided us a definition, right? And there's no definition of based on that's been provided by the legislature. So we should use ordinary language when defining based upon. You're with me on that? Okay. So in Saudi Arabia versus Nelson, the United States Supreme Court looked at a bunch of dictionaries and said the phrase based upon is most naturally, read most naturally to mean those elements of a claim that, if proven, would entitle a plaintiff to relief under his theory of the case. Do you agree that that's an acceptable way to approach based upon?
Would be an acceptable way to approach it.
So at that point, we have to think about what you have to prove for your third-party claim. And I was sort of using my hands before to show sort of the two levels. It's kind of a sandwich, right? That you have one level is the negligence of the city in hiring somebody who, didn't have inspection experience, but also you have to prove the negligence of in the process of the inspection, correct? That's another part of the third-party claim.
I understand that. I guess if I would push back a little bit, I would look at Justice Cady in IMT Insurance Company versus Crestmore Golf Club, where he's articulating the nature of the negligent retention and hiring claim, makes the point that the wrongful conduct of the employee is not that part of the tort which gives rise to liability. Liability arises from the failure of the employer to prevent the wrongful conduct.
We'd agree, though, that sounds like an incorrect statement of the law, though, wouldn't we? Because you've got to have both. If the employee, however unfit, however unqualified, completely terrible at their job, but if they don't mess up, if they don't have negligence or some other wrongful act, then the employer is never going to be liable to anybody for negligently hiring, retaining, supervising, correct?
And I guess, again, where I would push back is when you look at the elements of the tort in Goder versus Edwards and the restatement, And when you look at what our jury instructions are, I understand that we have language in our decisions that talk about the wrongful act of employee being necessary. It's not an element as it appears in our jury instructions.
I'm sorry. Thanks. Do you have a case where the employee was immune as a matter of law and the employer was nevertheless found liable under a negligent retention theory?
Negligent retention? No, but just the general question of employee immunity, you could look at, it's under Chapter 669 rather than 670. But in Hook versus Trevino, you had an immunity on the part of the employee, and the court still said that the employer was liable, or I should say the state was liable. The immunity was actually, it was a volunteer driver, so it wasn't an employee. But there was the tortfeasor, if you will, was immune, and the court said, nonetheless, despite that immunity, liability still existed against the state. So that, it's obviously, it's an analogy because it's a different chapter, but that would be, I guess, what I would point to, Your Honor.
I want to make sure I understand it correct. On behalf of your client, you were saying immunity does not apply because your claim is based on the city's decision to hire the building inspector, not the inspection itself. Is that correct? So if you look at another code section right above, it's still in 670.4 sub 1, but it's subsection B, any claim in connection with the assessment of or collection of taxes. So carrying your argument forward, does that mean no immunity if the tax collector does a really sloppy bad job of collecting? Would it be the same argument? Are we going to start getting into that with every situation?
And I apologize, would you give me the language of that?
Claim in connection with the assessment or collection of taxes. I'm just wondering, the same argument, wouldn't you be making the same argument if what's good for the goose is good for the gander?
I mean, if we're looking at our predicate phrase there, in connection with is different than either based on or arising out of. And so I would honestly have to study it, but my initial reaction is that the in connection with is broader than based on, because it suggests that as long as there's
Out of.
it's probably quite similar to arising out of. It's different than based on.
Distinctions only a lawyer could love, you know, between arising out of, based upon, in connection with. I mean, I recognize that we have these cases that say when the legislature uses different language, they often mean different things. But sometimes it's just, they mean the same things, and it's just, you know, the way they happen to write it over there.
I certainly understand and respect that it's a technical argument, but I think it's a technical argument that is due to the fact that we're looking at the language that's actually used.
Arises. You were going to say arises.
Yeah, I mean, I think, and if footnote 1 in Cubit wasn't there, then perhaps we wouldn't, I would feel less comfortable, but footnote 1 of Cubit shows that this court has wrestled with that language itself.
Rest the city's argument, if I understand it right, that the based upon distinction doesn't matter because the harm was caused by something outside the city's control, kind of their broader immunity argument that anything caused by, or harm caused by anything outside the city's control is also immune under this statute.
I don't think that's what 1J says, but there certainly is in the latter part of one. I mean, I think if I was the city, I would have been hanging my hat on just the word inspection, but that latter part of 1J is there, and that would limit that, it limits the first half of 1J. So I guess the way I would view that second half of that language is, let's say the city was negligent in inspecting a city-owned apartment, then even though it was an inspection, that immunity wouldn't apply.
So what about the otherwise language? I mean, could otherwise mean hiring, retention, supervision?
So when you look at the or otherwise, I think you just have to look at it in the context that you've got a list, and you look at what are other similar activities to the already listed items. I don't think it's a catch-all that's designed to say any activity is immunized. That would be, I guess, a breathtaking increase in the scope of that section.
What would one example be of what otherwise captures?
So it says, I think, issuance of a permit. Let's say it wasn't a permit, but it was a license. You know, that's not explicitly listed in there, but it's similar enough that it would fit within that same general concept.
If you read the statute, all of the language, whether by issuance of permit, inspection, all modify the words act or omission. I mean, couldn't you just read the statute that it's a claim based on an act or omission and there's immunity if the damage was caused by a third party? I mean, all of this other stuff is just an aside.
Well, it's not just an aside. I mean, I think it's a qualifier as to what types of acts and omissions matter. I mean,
That really what they're saying is that these are examples, possible examples, but it's not supposed to be exclusive.
It's possible, but if that was the intended breadth of this, then you really don't need very many of the other exceptions in 670.4 sub 1, because that is going to destroy almost all of the rest of the statute.
You and allow a negligent retention claim, even if or there's a case, or even if there's an immunity of the employee who's doing the inspection, are we going to undermine the immunity statute? You could evade the immunity statute simply by naming the employer for negligent hiring.
I don't think so. And I think that the reason why I don't is probably, I would look at the footnote 3 in Cubit, where footnote 3 in Cubit basically was saying we find that the immunity applies because the supervision was also in the course of an emergency. But if the supervision was not in the course of an emergency, then we wouldn't say that 1K applies as a matter of law. And so I think that that's the analysis that should also apply to here. And I don't think it destroys the statute. I think it's just a careful reading of it.
Mr. Postolka.
May it please the court, counsel? To start off, just briefly, again, there's all these statements about the potato chip driving and stuff like that. None of these things were included in the petition, and the city respectfully submits that the outcome of this case wouldn't necessarily change, but we ask that they be disregarded nonetheless.
Accept as true the factual allegations that he was unqualified for the job as a housing inspector?
If that is an allegation in the petition, that's a bare allegation, and that would fall under the sort of Twombly-Iqbal standards that Iowa observes as well. You have to state facts that support an actual claim.
Iqbal, we do say they have to be facts, but I hope your argument doesn't turn on whether these are the facts or not, because the standard is there shouldn't be a dismissal unless there's no state of facts that Mr. Voss could prove in support of his claim that would allow recovery. So if he comes in and says, this is the state of facts I'm going to be able to prove, you should be in a position to say that doesn't matter, right?
Your Honor, I agree, and that's why we didn't devote much of our brief to it, but I just wanted to say it to make the point.
Trevino, because I'm interested in whether there's a case within a case requirement, and in Hook v. Trevino, apparently there was a volunteer driver who was not an employee, but a volunteer who was found immune, and yet a claim for negligent hiring was allowed to proceed, or how was that case distinguishable?
I'll confess I'm not particularly familiar with Hook versus Trevino. I'm not sure it was discussed in the briefing, and at any rate, it was a 669 case, not a 670 case.
It was a vicarious liability. I could be wrong. I mean, I wrote it, but I believe, but do I remember it after 12 years?
My point is that I'm not sure exactly which immunity they were relying on. Obviously, it wasn't one of the ones in Chapter 670. But when we look at the 670 immunity, look, the word inspection is right there in the statute. That would obviously be the easiest way to resolve this case, is say, no, you can't angle shoot, you can't get around that immunity by alleging negligent hiring, retention, supervision. Yeah, that's a distinct tort. I agree with that, but we all know where that's going to go if those kinds of claims are allowed, and that's not what the legislature intended. My point, though, is that I think the or otherwise language removes all doubt.
I guess I struggle with the or otherwise. I tend to agree with Mr. Voss that otherwise means things like issuance of a permit, inspection, or investigation. That sort of, whatever is, somebody was throwing around that Latin phrase about, it draws its meaning from its comrades or whatever. Okay, well then, yeah. Anyway, it's known by nascitur sociis or whatever it is. Anyway, because otherwise it really would be an extraordinarily broad immunity. In other words, anything that a city, a municipality, school district wouldn't be liable for anything that was caused by a third party not under its control. And that seems very broad. I mean, there's all kinds of situations where you can say, there was a storm, there were all third-party events, but yet the city actively did things that could have prevented the harm and should be liable under sort of a normal negligence principle. It seems like a very broad immunity you're arguing for.
Certainly, we don't need to decide more than the case before us, but if anything would fit into the or otherwise language, it's a negligent supervision claim arising out of an inspection. And again, I reiterate, and this is with regard to the immunity and the public duty doctrine, if Inspector Goff had committed a tort, if Inspector Goff had certainly done something criminal, the city would be liable in those kinds of contexts. But when the only argument is that you should have hired a better housing inspector, a more qualified, not a criminal record or something, but just a better, more qualified housing inspector.
The city has a policy where it doesn't care if its inspectors actually go out and do their jobs. Let's say that they sit in the office all day and they don't actually go out and do it. Is there still immunity under the statute?
So, obviously, certainly I don't want to advocate for that position, but historically, going even back to the common law before immunity even existed, courts have never gotten in between cities and governments and how they try to enforce the law, how many police officers they allocate, how many inspectors they allocate, that kind of thing. Thank you.
Randolph versus Aidan and third-party appellant, City of Sioux City is hereby submitted, and we'll have